Our next segment speaks to immigration, B1 and B2 visas. It's going to be moderated by our friend Scott Hershenson, who is coming up to the stage here. There he is. Laura Knoll from Ali Moss, Rob Moss from Ali Moss, and the inimitable Graham Lord. What's your company now, Graham? Professional Yacht Crew Cayman. I'll leave the immigration deeds in y'all's hands.
Good afternoon, everybody. Scott Hershenson from the Hershenson Immigration Law Firm here moderating this discussion on B1, B2 visas. And I'm joined by an esteemed panel, Laura, Rob, and Graham. And we're going to go over and talk about what's going on with B1, B2s, explain how they are impacted with your industry with crew, and what we think is going to happen in the future. B1, B2s are the primary visas used by visitors coming to the United States. Most of them come on the B2 visitor for pleasure. And then you have the B1, which is a business visitor, someone who's coming to attend a seminar, someone who's coming to sign a contract. And in this particular situation, there is a distinct portion of the B1 for individuals who will serve as crew on foreign flagged or U.S. flagged pleasure vessels, private yachts. And anytime that someone is going to join a private vessel, that individual needs to have the proper visa in order to legally be allowed to come and be a part of that vessel. Now, the most important thing is to make sure that these individuals go through the proper hiring practices. These individuals, many of them are young in their early 20s, and they often jump from one vessel to another. It is imperative that these individuals have the proper documentation with their visas and that they are properly attached to each and every vessel that they're going to work at. They cannot simply come here at the boat show and decide that they are going to find a job and jump from one vessel to another. And they need to make sure that when they go and apply at the consulate, that they have a letter from their vessel and that they go in and apply and get the proper B1, B2 visa stamp showing their employment and detailing what they're going to do on board that vessel. Now, for Graham, when you're a business as a yacht management company, what do you advise for individuals who are looking to get jobs on different vessels, and how do they go about finding those jobs, and how do they document in order to make sure that they're properly doing everything right from an employment point of view to make sure that they're not violating any rules and the vessel and the vessel's owners are not going to have any issues?
The problem with the visas situation, there's more disinformation there than real information out there, and social media with the crew has been a real problem for us. Most recently, this seems to roll around every 7 to 10 years, where a thread starts, and there's a very recent thread that probably led to this discussion today of crew being deported out of the country because visas were incorrect, or a inspection happened to be in Palm Beach. I've looked into that really carefully, and I'll give a shout out to Patience Cohen at the Marine Industry Association of South Florida. She does an amazing job of staying in touch with Customs Border Patrol. But the bottom line about that is, when you start to look at these threads, the amount of disinformation is incredible. In that particular case, once we investigated it, nobody was deported because of a visa situation. It was actually a criminal situation that they tracked back to some inappropriate websites that they'd been on through their telephones. So that was the background on that. But to answer your question, Scott, is that B1, B2 visa is the right visa. When you apply for a B1, B2 visa, normally you get given both automatically. It's a good idea to apply for the C1D at the same time, because it's free if you do it in conjunction. So why not? When you enter the country, you want to enter on the B1 portion of it. A change on what they used to give you an I-94 card so you could see what the status was It's now done electronically, and I think we're going to share that website. But what I recommend to the captain or the crew is look at that to make sure your information has been entered correctly, because that is the gospel. And the B1 status is the right way. Most visas, depending on which consulate or embassy you go to in the world, will issue a 10-year visa if you have the satisfactory documentation. The most important piece of documentation is proof that you're not going to try live in the States. And that is normally a utility bill. For young people that don't own properties, what we recommend is that they speak to their parents or a family member and put a water bill, electrical bill in their name, and just make an arrangement that's reimbursed so they can pay the bill. So you have proof of evidence somewhere else. The other thing that we recommend to all of our crew, we have about 800 crew in our portfolio, get off social media. Customs Border Patrol can see all of your social media, even if you think that you are blocked, you're not to them. The case before, that was a problematic case, and speaking to the officer directly of what that officer found, the individual came in and had photos of the house that they just bought with his partner on Las Olas, along with a puppy that they were. So clear evidence that person was living in the U.S. So that's the advice. I think we'll touch a little bit later on. Once somebody's here, should you hire or shouldn't you hire and that, but I'll leave that to smarter people than me.
Thank you. And one excellent point that Graham didn't make is the I-94 card, which everybody who's not a green card holder or a U.S. citizen, every single time you enter, whether you're on ESTA or come with a visa, you used to be given a little white or green I-94 card by the customs officer that dictated exactly how long you could remain in the United States and exactly what classification they admitted you in. They no longer do that. Everything is electronic I-94 card. So even people coming on ESTAs, you want to always check your electronic I-94 card so you know exactly how long you can stay here and exactly what classification. Because if someone's coming in on your boat and they came with the B1 and the individual, instead of getting the usual 6 months, if they were actually only given 60 days or 6 days, that's the allowable time that they can spend inside the United States. So always check your I-94 cards once you enter the United States. Tax issues. I'll leave this to the experts.
Okay. It is not the case, as some you're talking about lore within the yacht industry, that because a foreign crewman is working on a foreign vessel, that they're not subject to U.S. taxes. That's simply not true. There are a couple of ways that you can trigger a tax obligation. One is if you're here for more than 90 days and paid more than $3,000 for U.S.-based labor. The other is if you can become a tax resident if you're here for 180 days within a 12-month period. So it is something which I think all crewmen and owners need to be aware of. I mean, historically, there hasn't been much withholding for foreign crew, but that doesn't make it right. Some foreign crewmen are able to benefit from tax treaties, which say that they, basically, if you have a bona fide residence in a foreign country and you're not in the U.S. more than 183 days during the year, that you could potentially claim treaty benefits. But you have to have a bona fide residence in a foreign country generally to do that. The other issue is similar with U.S. crewmen, except that as to them, there is no exception. I mean, there may be a very narrow exception if you're outside the U.S., living outside the U.S., and you have a bona fide residence, and you're outside the U.S. for more than 330 days during the year. You can a certain portion of your income is not subject to tax. So, as I always say to my clients, this is something that you ignore at your peril. Foreign crewmen don't like the concept of having tax withheld on their income, but in most cases it's required. And Graham, I know this is something you've wrestled with. How are you handling it?
It's a very sticky point because most understanding who's responsible becomes the key piece. The crew member is not responsible. That I can say definitively. The IRS looks at multiple different factors, but a decision maker is responsible. So, for example, if a management company is making decisions for the vessel, they're responsible. If a owner is making decisions, they're a responsible party, and it can be multiple responsible parties.
You're talking about failure to withhold.
Failure to withhold. Because that is the concept right now for 99% of the industry. There's a clause in the employment agreement which says the crew member will take care of their own tax responsibilities. That does not follow the IRS requirements. In which case, for most of the people here, it might be associated in their firms with a management company or something along those lines. You are putting yourself in the firing line. The only thing that we've had as somewhat of an advantage as the industry is that in order to withhold those taxes, the foreign crew member has to get a TIN number, tax identification number. Homeland Security is not keen on people getting TIN numbers because with that you can get a driver's license. And that's what the terrorists use in 9/11 to appear as Americans. So there is a bit of a gray area where Homeland Security is saying to IRS, we don't want this implemented. But the law is clear on this, and you are on the gray side if you're not abiding.
I would just add to that what we're seeing in the client requests are two things. First, a lot of interest in a rotational program. So you could have two captains and they could rotate out and neither one of them could violate the 180-day rule. And then we also are seeing a lot more clients refusing to independent contractor their captains and employees. And that's always been the rule. The IRS test for whether someone is an independent contractor generally fails for yacht crew that work on just one single vessel. But we know that as an industry, it has momentum, that the captains have been used to having their own LLC and being independent contractor. But we're advising, especially when you start a new relationship with a new employee, to please try to direct them to do the employee status.
And one might ask, well, how does this come up? And the answer is the IRS is not sending agents out to walk up and down the docks and question crew. This generally comes up on an IRS audit of the owner's return or returns. And if they see that he owns a boat, then one question leads to another. Does the boat have crew? And then are you withholding? So I've seen this, I don't know, maybe 10 times over the years where people are having to try to explain why they didn't withhold. And if you didn't withhold, even though it's not your taxes that weren't paid, you have full liability and plus penalties and interest. So it can be a very serious issue.
And I think it's safe to say with the new administration that different enforcements, whether it be taxes or coming in checking visas, are certainly going to be much more common over the next few years.
I just want to chime in on Rob's, where we've seen it triggered is American crew that were hired as subcontractors get terminated under bad circumstances and claim unemployment. And that triggers a phone hearing. And if any of you have done those, it's actually pretty intimidating because you're on the phone with a judge and you're swearing to tell the truth and the whole truth. So it's a pretty intimidating phone call. In my business in Cayman, we are the employer. So I'm taking all the liabilities and we're following the letter of the law. We do lose about 70%, we lose about 30% of our inquiries based on that. But again, they're my employees. I'm not taking the risk.
So in the past, the B1 private crew were required or were restricted to only work on foreign flag vessels. And a few years ago, the Foreign Affairs Manual got updated to state that B1 private crew could work on U.S. flag vessels as long as they did not have a foreign residence that they planned to leave. This was a huge change in the industry for B1 crew. There was very little fanfare by the State Department on the Foreign Affairs Manual. I think that a lot of CBP officers that are not in the South Florida area still are not aware of this, but this is a huge change to allow U.S. flag vessels to have B1 private crew without any issues. Now, there is an exception, and why don't you talk about the different exceptions to that?
Sure. So generally, for a U.S. vessel, you should have U.S. crew. There's an exception that the general rule is that a U.S. vessel can only be placed under the command of a U.S. citizen. An exception to the general rule is that a vessel with only a recreational endorsement may be placed under the command of a non-citizen. So you could have a smaller sport fish or something type vessel where you have a non-U.S. crew member. But the issue that we ran into before the change in the Foreign Affairs Manual was that they couldn't get the visa because they didn't sail out of a foreign home port because the vessel was U.S. documented. Now that there's that change, they can get the visa to work on that vessel. When you get into the higher tonnages, there's another convention called the Officers Competency Convention that's up on the slide, and it basically creates a citizenship requirement, a little bit circular way, but you have to be a citizen in order to get the U.S. credential, and therefore you must be a U.S. citizen in order to serve in certain positions on the vessel. But even for larger, over 200 gross ton U.S. vessels, you could still have, because this change in the Foreign Affairs Manual, you could still have a foreign stew. If that stew from South Africa is the best fit for the family, and then, just make sure that she's getting the right visa.
In your opinion, any chance that rule is going to change regarding the officer competency, OCC? You think?
No.
No.
No, solid no. But I think it's important for everybody in this room to absorb this. For U.S. clients, especially if they want to go for depreciation, the U.S. flag is quite a sexy way to do it. But it was always a problem on anything with more than 2 or 3 crew to find a good balance of American crews. So it does open up the doors for unlicensed, which maybe be the easiest layman's terms to put it. You still have to have a U.S. Coast Guard license, which you have to be American citizen to get. But if it's unlicensed crew, chefs, stewardesses, deckhands, it opens it up a lot. And we have in our portfolio probably in excess of 100 crew, which we've been using this system for the last 2 or 3 years. We do have a cover letter showing the where to look in the FAM manual to help an immigration officer may not be familiar. And we've had no problem at all, not a single incident. Even though after the elections, there was a huge spike in, and this is all false, but the huge spike was that Customs Border Patrol have been giving new orders in South Florida, that there's going to be a new enforcement. That is not true. Nothing has changed. We've experienced no problems at all.
Yeah, and I agree that our clients are still able to go get B1 visas all the time. They haven't had any issues. There's been 1 or 2 people who got stopped at a port and had a few more questions than usual, but haven't had any issues overall. And for those who want to know the Foreign Affairs Manual, we can certainly, you can take a look. We can send you the exact change. And let's talk about vessels at charter.
So the last slide, the change, if you go back, the keywords there, regardless of nationality of the yacht. And this is what the Foreign Affairs Manual, I took a screenshot of this because I gave this presentation to a bunch of lawyers, the Maritime Law Association. And this is the date, it's dated 2019. And it was like, wow, what a gift. How great. And then you go to the next slide and look, they helped us by adding more, but it didn't add anything. It's terribly confusing. And I've actually called patients and been like, were you guys responsible for this? Like, who told them to go here? And we're not really sure, but what they have added to this B1 language now is that you should be aware that privately owned yachts may be chartered while abroad, but used for personal use while in U.S. territorial waters, and websites related to charter business may not reflect that. They seem to be saying that if the yacht is chartering, that you couldn't get the visa for that type of yacht. That's my interpretation of it.
You can't. I mean, the key there is that it is aboard a recreational vessel. And I was always of the view that a bareboat charter would be deemed a recreational use, because under the Coast Guard regulations, it specifically states with respect to a recreational endorsement that it does allow bareboat charters. But that's not how CBP, at least in South Florida, is looking at. And Laura just put up the slide here, or Scott, sorry, that says recreational vessel is one that's leased or chartered to another for latter's pleasure. But CBP is not bound by Coast Guard definitions.
Correct.
I think it's wrong, but at least CBP in South Florida is policing it that way. You can't use the B1 on a boat that's being chartered on a bareboat basis, even though under Coast Guard rules, that's a recreational use.
Scott, you could go back one more.
So there's a link to another part of the Foreign Affairs Manual, so you could really dive deep here. And there's another subsection, 3U, chartered versus non-chartered recreational vessels. Whether a recreational vessel will be chartered or has been previously chartered is irrelevant for visa classification purposes. For the B1, you must determine whether an applicant will be providing services on a recreational vessel based upon their proposed purpose of travel at the time of entry. So I don't know if the crew are saying if they try and come in and just say, well, it's offered for charter, but we don't get any bookings for the U.S. We only get Bahama bookings. I don't know if that matters, if we're seeing that in practice, Graham, if they're getting that question at the time of entry, if the vessel charters.
We haven't seen any enforcement of that at all.
Although for purposes of the cruising license, they do look at whether the boat's on a website and being chartered. So I suppose they could do the same here, although we at least have the specific provision from the Foreign Affairs Manual to point to that says, hey guys, it has to be chartering here, not outside the U.S. for that to be an issue on use of the B1.
And I agree with Graham that none of our clients have told us that they've been asked that question when they're applying for B1 visas, but as you point out, it certainly could be an issue down the road.
Yeah.
Any questions? The one in the back.
No questions from the audience? Birdo never lets me down.
While Paul's walking the mic up there, I just want to touch on the B1, B2 visas. So B1, B2 visas can either be issued in a 1 year, 5 year, or 10-year grouping. Obviously, 10 years is your best option, and supporting the paperwork is very helpful. But every consulate or embassy around the world gets issued a certain amount of each visa every year. So it's a good idea, and the chat groups with the crew do a very good job to follow who's currently issuing long-term visas, because it means they have them. And they may not run out of the 10 years. So even if you have really good paperwork, they're going to issue the next one down. So you may have the paperwork for a 10-year, but end up with a 1 year. Tracking what the visas, who's got good supply of those visas on an annual basis is a good idea. The second thing is when you enter the country on a B1, B2, you're allowed in for 6 months at a time. That can be extended for another 6 months. A common mistake, and Scott might want to touch on this, is you don't necessarily have to leave the country. You can apply for extension. And doing the visa runs, this is where we see most of the problem. Doing an overnight run across to Nassau and back is more problematic than just applying for an extension. Once you've done 2 6-month stints in a row, then you do have to leave.
Absolutely. People who are just trying to jump out for a weekend and come back, those are the people that ideally are getting targeted by CBP and usually have the most difficult amount of time. And one point regarding B1, B2, most consulates take anywhere from 2 weeks to 2 years to get an appointment because of how backlogged the visas are. There was a State Department website that was pretty accurate and used to provide daily updates as to how long each consulate would take for the waiting list. Unfortunately, the Trump administration took that down last week, so now everybody's kind of flying blind as to how long the wait lists are going to be. You can't forum shop and say, hey, I'm going to go to Nassau or I'm going to go to Joburg or San Jose, because they may have a shorter wait time. Nobody knows anymore. And a question.
Yeah, what do you recommend when a crew member comes in, goes through immigration, and they stamp the passport, the visa, with the B2 instead of a B1?
So they no longer technically stamp it anymore. They no longer give an admission stamp in the passport. Everything's done electronically now, and that's why we recommend that each individual check their electronic website, I-94 website, within 24 hours of admission. And if they were given the wrong amount of time or the wrong classification, there is a procedure where you can contact deferred inspections. Every port and every airport and seaport has a local deferred inspection where you can contact them and make a request to have the proper admission classification or time corrected. Unfortunately, with deferred inspection, it's entirely discretionary. They don't have to decide to give you a different classification or different amount of time. If your electronic admission says X and that's all they're going to give you, you're stuck with that.
And how responsive are they?
Excellent point. Some offices down here, for example, Miami and Palm Beach, are very quick to act. Other ports, very slow. I had an incident recently in a Canadian coming down on a B2 visit, and they were a family of four. Mother, father, older son, all got the proper 6 months. The 3-year-old toddler was given 4 weeks. And
Get him out.
And nobody noticed until they checked their I-94 card, and their infant son was now here out of status. So we contacted Buffalo Deferred Inspection because they entered in Buffalo, and Buffalo said, sorry, that was the officer's decision, nothing we could do. So now they left the U.S. because their child was here out of status. And unfortunately, that child is now going to have to report on every government application that they were out of status at any point in their life, and have to explain that when I was 3 years old, I was given less time than the rest of my family, and it's just going to be a pain in the butt for that child as they grow up to always have to show and disclose that they were here out of status.
Scott, do you see any crew on charter yachts trying to use C1Ds?
Very, very rarely. C1Ds are almost entirely for commercial fishing vessels and cruise lines, Carnival, Norwegian, that they're limited to just 29 days per entry. They cannot extend their stay. They cannot change their status. Even if they got married to a U.S. citizen, they could not apply for a green card in the U.S. C1D is, you cannot do anything with it. So we really never see that.
But they're eligible.
In theory, they're eligible. I haven't seen anybody use that issue in years.
Any other
The only time I
questions
could
from the
potentially
audience?
seeing it come up if you have a boat that's in the USVI where there's no, the coastwise laws don't apply, and it's not in the U.S. Customs territory. You still have to comply with immigration requirements. And if you want to conduct a charter on, say, a MYBA form, where it's not a bareboat, although it probably doesn't matter, you couldn't do that with a B1. You would have to have C1D visa. So it's a possible narrow exception to
That's
not
true.
using it.
So having both, as Graham mentioned, is always a good backup, but 99.9% of the time, just the B1 is going to be sufficient.
How about on an IYBA form? Any other
Oh, I'm
questions?
sorry.
from the audience?
What have I said?
Paul, I just wanted to put in real quick that where we started with disinformation is often harder to correct than real information. Marine Industries Association of South Florida during FLIBS, normally on a Friday or Saturday afternoon, host an event. It's free. They have 4 immigration officers from Miami, 4 from Fort Lauderdale, 4 from Palm Beach, and 2 of the supervisors get flown in from Washington, D.C. So you got 14 people with guns, and they are very open to answer any questions. And most of the time, they outnumber the amount of people that show up from the industry. If you have any influence over captains, I really would recommend make them aware of that. It would help us all if there was a bigger turnout. And every one of those 14 officers will give you their personal or their work cell phone number, and they will answer that cell phone number. So you walk away with a really valuable ally if you show up to that.
It's not only that. I mean, I've attended one of those meetings, but also there are some things that if you think they've been applying a rule or statute wrongly, this is your chance to say, hey guys, this is what black letter law says. And we had one instance when I attended where they were just misinformed. So
Hang on. Shout it out. It's polite society here.
No, I just wanted to add to what Graham just said. There's actually a CBP and U.S. Coast Guard talk on Friday. I believe it's around noon or 1. I forget what time at the Superyacht Times or the Village where they're doing all the educational talks. The CBP and U.S. Coast Guard will be there on Friday as well specifically for captain and crew to come ask questions.
Yeah, what you'll find if you attend those is these are just normal people who've got a job that they're trying to enforce. So once you have a rapport with them and you've got their mobile number, you'll see the human side come out, and they'll work with you. They're just normal people trying to earn a salary.
Those are the other educational events. All shameless self-promotion is limited to IYBA and MYBA at this event. But thank you. At 2 p.m. Friday, and the Superyacht at Palm Harbor, they have this new pavilion there, correct? So it's right across the street. So if you got nothing else to do on Friday, that's the place to be. Do we have any other comments or questions? So I think the gist of it is, this is very, very technical. It's very confusing. If you're a lawyer, call a friend. If you're not a lawyer, make a friend. Find somebody who can give you the good information. Don't get tripped up. Don't get caught short, and help advise the people that are seeking the good advice and guidance from you. Thank you so much, Scott, Laura, Rob, and Graham. That was a very good presentation. And I have to say, the socks are outstanding, but you got trumped by Scott. Scott's got better socks. Yeah, buddy. IYBA